All right, so state on this one, there was some sort of surveillance video.
Judge, I believe discovery hasn't been tendered in the case, but we are doing additional research regarding,
William Barr.
yes, so it's my understanding that he may have been cited for this offense.
Okay.
And so I need to reach out to the municipal court and receive the information regarding what they did with that to decide whether I can proceed or not on my case.
All right. Ms. Ferguson, this will be the final discovery date. I need a 30-day reset for discovery.
July 10th.
All right, July 10th. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you.
You're welcome. Thank you. All right, Roger Mims.
We're ready, Judge.
Hello.
Good morning, Judge.
Good morning. So you all are scheduled for jury trial.
Yes, ma'am.
See y'all back at 1:30.
1:30?
Mhm. Amelia Lopez.
Hi, Judge. How you doing?
Hi, I'm doing okay. How are you doing?
Very good. That, yeah, yeah. Yeah.
Are you all ready to proceed?
Yes, Judge.
Oh.
Ready, Your Honor.
All right, just give me one moment. All right, the court is calling. I'm sorry, are you ready?
Oh, yes.
All right, court is calling 2025 CR 0019990. State versus Amelia Lopez. Can I have parties announced for the record?
Rick Fainer for the state of Texas.
Larry Bloomquist for the defense.
And are you Amelia Lopez?
Yes, Your Honor.
All right, you entered a plea of guilty on April 15th to the offense of burglary of a habitation. According to your plea bargain agreement, punishment is to be assessed at a cap of 5 silent. There is a $1,500 fine, and there's to be no contact with the complainant. Parties waived PSI. Does anyone have any witnesses?
I do, Your Honor. And I'd like to just make a quick opening and then I'll call some witnesses, Your Honor.
All right, yes.
Judge, I mean, this situation, and we have Amelia Lopez, prior to this event, he was studying to become a firefighter. He was attending college classes to become a firefighter. He's going through a breakup. He has a kind of a bad breakup. He's very emotionally connected to this person. He goes to her house. He wants to talk with her. And then it just gets kind of crazy from the,
And I'm so sorry.
no problem, Judge.
Let me see if the jury's available
Sure thing.
and do this closing argument, and then I'll take your matter up.
Perfect, Judge.
All right, thank you. Who's here on Anthony Villarreal?
Charles Gold, Your Honor.
Yes, that's at 1:30.
Where's
the client?
He's right. Yeah, I thought we were here this morning. Judge, I'm sorry. Right, yeah. Yes, and also I have a ALR at 1 and a dentist appointment at 2:30.
Oh, that's just what they're doing. That's not. In ranking, this is first. Have your client come up.
Alicia, my daughter. You saw the closing right there? That's cool. Juice. My 16-year-old's here.
Oh.
Well,
wait, Then we need to meet her.
Show up. Yeah, of course, sir.
You didn't know this? She may still have it.
All
I
right,
don't know.
so, you all are saying this case is going to resolve itself?
It may. It's just, it's.
I gave him some new
They gave
information.
New information yesterday. And it's something that I feel that I need to probably get to the end of it.
All right, so when is this gonna happen?
Next 30 days.
All right, so this is what I'm gonna tell everybody. I'm setting it for disposition. If it's not worked out on this date, you all are going to jury trial.
That's good.
All right, Ms. Ferguson, I need a 30-day reset.
Yes, ma'am. I'll do July 10th, Judge.
All right, and July 10th?
Let me double check. It should be a good judge. If
Oh,
not.
it's good.
We get to Cleo. July the 10th.
Oh, it's a beautiful day. All right, thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Thank you.
All right, thank you.
Yeah, I'm wide open that day.
Hi.
All right, Mr. Bloomquist,
Yeah.
are you ready?
Yes.
And do we, I can't see over my thing.
Anthony Villarreal. Slide.
Bill, make sure you speak loud enough for the court reporter to hear you.
We're back on the record in 2025 CR 001990, State versus Emilio Lopez. And can I have parties reannounce?
Rick Pena for the state of Texas.
Larry Bloomquist for the defense.
All right, and Mr. Bloomquist, you have begun your
Yeah.
opening for the court.
Yes, Judge. I just want to clarify for the court. So my client was in a relationship with the victim. They had been in a lot of a dating relationship. That relationship had gone south. My client was very distraught about that. He went to her home to talk with her. I believe the evidence is going to show he didn't have any intent to commit any act of violence against her during that. She opens the door. She's very upset to see him. She starts to yell. Things get out of control. He does push his way into her apartment and does commit burglary. At some point, she's yelling and he falls on top of her. It's a really regrettable situation. I think the evidence is going to show that Mr. Lopez is taking full responsibility for the actions that he did that day. I believe he understands that what he did was wrong, and then also think the evidence is going to show that this is out of character for Mr. Lopez. And now I'll just call my first witness.
All right,
Can I call Emily Lopez?
all right, you'll need to step that way.
She's just on
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Emily Lopez.
All right, make sure you keep your voice up so that I can hear.
Okay.
All right, defense, you may proceed.
And how are you related to Emilio Lopez?
He's my little brother,
Okay. And what's the age difference between the two of you?
3 years.
And is he the youngest child in your family?
Yes, sir.
And how many other siblings do you have?
One older brother.
And where did you grow up? Okay, what kind of kid was Emilio as you were growing up?
He was a lot. He was very active, very fun. He was very well liked by his friends and our family. If we have younger siblings, we all love him a lot.
I think you told me that he was kind of a quiet kid, but all the kids in school liked him. Can you describe that for the court?
Yeah, so he's very active at home. In school, he was more on the quiet side. But even then, even like that, the other students would always follow him around and his opinion, and just like the teachers would kind of use him to guide other students in a way.
Okay. And then your mom did she have epilepsy?
She gets seizures.
Okay, so she would have seizures.
Mhm.
Tell me about how Amelia would react when your mom had seizures.
Well, the first time it happened, he was by himself. He took care of her on his own. But then after that, it was me and my siblings there. But he was a lot calmer, and so he was able to help guide me and my older brother on what to do to help her in the situation and to make sure everybody was safe.
Okay. And that was something that he kind of did whenever she would have a seizure. He would kind of step forward,
Mhm.
even though he was the youngest.
Yes.
The last couple years, so what city do you reside in?
Bryan, Texas.
And at some point, did Emilio come to live with you in Bryan?
Yes, 2 years ago.
Okay. And so when he came there to what was he doing in Bryan?
He was working and trying to get college hours so he could apply to be a firefighter.
Okay. And when he was going through this program to become a firefighter, are you aware that that's no longer an option for him now because of the felony charge, felony arrest and all that?
Yes, sir.
Okay. And then, was that something he really cared about, was trying to become a firefighter?
Yes, sir.
As far as work, where's he been working since he's been there in Bryan, College Station?
He worked at Blaze Pizza. He was a shift lead there, I think.
Mhm.
And then he was also a shift lead at a barbecue place.
Okay. And is it true that he won employee of the month multiple months during the time he was working there?
Yes, sir.
During the time that Amelia was going through this breakup, did you notice a change in his behavior?
Yeah, he was a lot more, I don't know, like reserved. He spent a lot of time in his room, didn't
Mhm.
really interact with us that much anymore.
Okay.
Can you keep your voice up, please?
And was he really hurt when the relationship ended?
Yes, sir.
And is there anything you want the judge to know before she makes, decides the sentence of Amelia?
We just care about him a lot, so, and I recognize he made a mistake and, or he has owned up to it.
And that's something he's been doing throughout this process, is taking responsibility for what he did.
Yes, sir.
And has he expressed to you that he's upset about how his actions have affected the rest of the people in the family?
Yes, sir.
And how has he done that?
Well, he's told me outright that he knows that he shouldn't have done that. He shouldn't have put her in that situation, but also he recognizes that we've been affected by it as well.
Okay. And if the judge were to grant Emilio probation, do you have any doubt that he would do everything he could to be successful in doing that? I'll pass witness.
Any questions?
Just a few questions now. I couldn't hear a little bit at the beginning, but you said he's your little brother?
Yes,
And how far apart are you guys in age?
3 years.
3 years, okay. You're aware that he was in a relationship with the victim in the case? Do you know how long they were dating?
Probably a year and a half.
Do you know if this was his first relationship ever with the girl?
Yes.
First one, okay. Do you feel that men who do what he did to a woman should be properly punished? No further questions, Ron.
All right, thank you so much.
We'll call.
All right, before you call your next witness, because I'd like to get to the point. This is my understanding, you can come back. This is my understanding of the facts of this case. How old are you? 22. And at the time this happened in 2024, you're maybe 21.
Yes, sir.
All right. So what I'm hearing is that you were in a relationship with someone. Your sister testified that this is the first relationship he's ever heard. Does anyone doubt that this was his first relationship?
At this point, I don't have any doubts about that.
All right, so he's in a relationship with somebody for a year. And if my reading of the facts are incorrect, let me know. He's in a relationship with her for a year. They end up breaking up. According to police reports, they're either breaking up by text or phone. And then sometimes they would get back together, then break up again and get back together. He's in College Station. He finds out that during the relationship that maybe he wasn't the only person she was dating. I'll put it that way. So for some reason, this 21-year-old drives all the way from College Station to San Antonio. How long a drive is that?
About 3.5, 4 hours, Your Honor.
3 and 4 hours to talk to her about the breakup of their relationship, and he wants to get back together. So he comes back to the apartment. In the apartment is the complainant he was dating, the complainant's sister, and the sister's boyfriend. Now, they say that he knocks on the door or whatever. No, he enters the door with a key because he had made a copy of the key, which she didn't know he had made a copy of the key during their relationship. She sees him opening the door or whatever. He ends up entering the habitation, which anytime you enter a habitation without permission, any parts of your body or whatever, That becomes the burglary. And then he is talking to her, pushing her back to the room, want to talk about the breakup of the relationship or the facts that she maybe was untrue to him. They go into her bedroom. He's pushing her towards the bedroom. Police report, he wants to talk to her. In the report, she says that he has a pocket knife. The officer says, he questions him. He says, yes, I do own a pocket knife, but I never displayed a pocket knife. He never left the apartment. The police don't find a pocket knife in the apartment or a pocket knife on him. Is that correct?
Yes, I
To
believe
an
so.
yes, but there's,
But I mean, there's no pocket knife ever found. Did somebody find a pocket knife?
if, as an officer of the court, I can say I've spoken to the victim and her sister, and a pocket knife was found by them underneath the victim's bed in her bedroom.
All right, did somebody call the police and say, hey, you didn't do a proper search? There's a pocket knife underneath the bed?
And I believe they did that after the fact, no.
All right, so
And let
according
me just
to,
add one thing to that, Judge. When he's asked, I think the police officer asked him while he's, because he, after the event, he sits on the stoop and waits for the police to be called. And then when the police officer comes, I think he told him that he had the pocket knife always, that he uses it for his job, but he didn't use it in any way.
oh no, I mean, I'm just going by
Yes,
what
sir.
the police
Yes, Your
report
Honor.
says. Police report says suspect, that's you, stated he did have a pocket knife on his person, but never displayed or brandished the weapon to the victim or other persons in the apartment. It should be documented that the pocket knife was not found on his person or inside the apartment. So now let's get to the point. State is silent, which means they want me to determine whether or not he should go to prison or whether or not he should be placed on deferred adjudication. Does the complainant want him in prison? Does anybody know?
She's right here, Your Honor.
You want to ask her?
Can go ask.
And this is just something for me to consider. It's not saying I'll send him to prison. It's just for me to
No, I
consider.
understand, Judge.
Yeah.
I mean, that's a reasonable.
Victim would like prison.
All right. All right, I'll hear the remaining of your witnesses.
Okay, Your Honor, I call him Emilio Lopez Senior.
All right. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth or nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up because I have to hear and the court reporter has to hear. All right, if you'll state your name for the record.
Emilio Lopez.
All right, defense, you may proceed.
And how are you related to this other young Emilio Lopez?
It's a good son and trying to make a good life.
Okay, and where did Emilio grow up? What city did he grow up in?
Broadview.
Okay, and then prior to, and what kind of child was he?
So just a second.
Yeah.
So it would help if you don't turn
Yeah.
towards the defense
Oh.
counsel because you're turning your back
Yeah.
to
okay.
the court reporter.
Yeah.
All right, if you all want to speak closer to the court reporter, you can. I
Yeah.
can hear you from over here.
Okay,
So,
yeah, just keep your voice up because there's always, just when you have 20 people in a room, there's always some shuffling. What kind of child was he growing up?
A good son and trying to get a good life.
Has Emilio ever been in trouble before? Has he ever been arrested for any crime prior to this?
No.
Has Emilio consistently throughout his young life, has he consistently worked at different jobs?
James and Broadview and then in Bryan, Texas.
Okay. And if he is granted probation, would he have a place to stay there with you in either Brownsville?
Yes, in my house.
Okay. And would you also, do you believe that he would follow all rules that the court gave him and do everything he could if he was given orders by the court to follow those orders?
Yes, gonna do it.
Okay. Has Emilio in his entire life, has he ever shown any acts of violence or any time has he been a violent person?
No, no.
Is there anything you'd like to tell the judge prior to you entering the sentence in this case?
Well, he has sorry. He made a mistake and he's gonna try to be a good boy and good son, like every time.
I'll pass witness at this time.
any questions?
Just a few questions.
Well, I mean, you state you're silent. So if has something to do with any facts that are in dispute.
Not the
then-
facts. I'm just gonna ask about questions that he was testified to with his relationship with his son, if that's okay. Okay.
I mean,
No
unless the defense has no objection. Yeah, that's fine.
questions then. Okay.
All right, I have some questions. Excuse me.
sir.
Yeah, I have a few questions for you. So, first of all, these are not mistakes your son made. These are choices. He chose to get in a vehicle and drive, right? From
Yes,
College Station to here. So, were you ever aware of his relationship with the complainant? Did you all ever discuss his relationship with the complainant?
I asked him, sometimes, how was your relation? And he said, it was a good relation.
So you're somebody that he can come to or could come to if there were relationship issues.
No, you never told me, but we have seen.
No, I'm talking about in general. Do you and your son have a close relationship? Because the defense has called you,
Okay, okay.
hopefully, and I think he's calling you because you have a close relationship with your son.
Yes, yeah.
He said he's 22 years old, so you've known him for 22 years. So what is your relationship like with him? Does he discuss with you any relationship issues he's having or any other issues he's having with his life?
No, just, we talk a lot about the jobs and the school and all that. Not the relationship.
All right, so my question is then, did he ever speak to you about his relationship with the complainant in this case?
No,
Did he ever ask you any advice about his relationship with the complainant in this case?
no, it just, I would ask him, how was your relation? And he said, was a good relation.
Okay, all right, thank you so much for coming down.
Thank you. And Your Honor, at this time, I call my client, Emilio Lopez.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Emilio Lopez.
All right, you may proceed.
So Emilio, throughout this process, let me back up. So have you been working, let's talk about right before this happened. So you were going to school. What was your goal to become?
My goal was to become a firefighter, and if that didn't work out, I wanted to pursue a career in either IT or join a trade.
Okay. And you were also working at various restaurants during this period of time?
Yes,
And during this period of time, were you being promoted at these restaurants to like supervisory roles?
yes, and Blaze Pizza, I was a supervisor now, and they were in the talks of making me assistant general manager,
Mhm.
but I had to quit due to a toxic work environment.
Okay. And then also when you eventually worked at a barbecue restaurant and you were hired on as a management trainee, is that correct?
Yes,
But that company then failed,
yeah, it went under.
it went under. Okay. And then, are you going to be able to be a firefighter now because of these charges? Is that possible for you anymore?
Unfortunately, due to my choices, those doors, they've closed.
Okay.
But if after, like, whatever happens after this, my goal is to still go to college and pursue something that I can do.
Okay. And then the victim in this case, how long were you guys in a relationship for?
I believe it was 2 years, either a year and a half.
Okay. And when this relationship ended, was that emotionally disturbing to you?
Yes, it hit hard, really badly. It was very, I was very distraught.
Okay. And during this time when you were distraught, at some point were you kind of off again, on again for a while?
It was only once. After the breakup, I decided to just work on myself,
Mhm.
and I believe it was in October. She reached out to me saying that she wanted to get back with me, and I accepted.
Mhm. But she continued to message you during this period of time after the breakup?
Yes,
Okay. And at this point, when you actually decided to go to her house, what was your intentions when you were going to the house?
I wanted to discuss. Again, I found out that during our relationship, our second time getting back together, she was I guess cheating on me. She was doing things behind my back with other people, and it just I felt very betrayed and just ashamed.
Okay. But the purpose in driving from her house, well, first of all, let's talk. Did you have a key to her house?
I did was when we got back together, I asked like, hey, like, is it okay if I can stay over, find a job, earn some money, and then go back to college? Because the job in College Station, since it was near the end of the semester, a lot of students left, and there wasn't any jobs
Mhm.
to go for. So I asked her if it's okay if I can live with her.
And how long did you stay with her?
I believe it was I believe it was 2 weeks.
And during that time, you got a key to her house, is that correct?
Yes, we first discussed because I went with her to get a key, and it was at Walmart, but the key thing didn't work.
Mhm.
And the next day, I just went to get another one without her. She was at work.
Okay. But during that period of time, you were actually staying at the house for those 2 weeks full time?
Yes.
And was it your intention initially to stay longer than that?
By the end of I'd say like I would go home next year when my second semester started.
Okay. But initially, you were gonna be there for longer than 2 weeks, is
Yeah.
that correct? Your plan initially was to stay there for how long?
I'd say I think I stayed there till or
Not how long were you there? How long did you plan to be there when you were staying there?
I'd say 2, 3 months.
Okay. Why did you leave after 2 weeks?
I discovered so when we were together, we were both comfortable with each other, like taking our phones. You know, sometimes she would take my phone and just
Mhm.
do whatever she wants with my phone. And I discovered that someone was messaging her, and I saw, and it was an unknown name.
Okay.
And
That's why you left?
yes,
Okay.
and that's when I found out.
When
about
you
that.
were going there, was it your intention to hurt or scare her?
No,
What was your intention when you got to the house?
well, it was to discuss like as to why she did that to me, and if it was what we had, what like if it was genuine.
And why did you decide to do that in person or rather than over the phone?
Because in the phone, she would just not text me. She would ignore me, and I kind of I just wanted to discuss as to why she did what she did.
And how did you actually get into the apartment?
I believe she opened the door, and that's when the fight occurred.
When she saw you, she was upset, correct?
Yes,
Did she start yelling?
I believe so.
Okay. And you did push her into the apartment, correct?
Yes.
And then at some point, she were you trying to hurt her at any time inside the apartment?
No.
Well, again, why were but you guys were in physical contact, correct?
Yes.
And at some point you both fell down?
Yes. I believe it was in her room. From what I know, I tripped on something because usually her room is very dirty, and I think I tripped either in a piece of clothing or just something that was near my foot.
Okay. I mean, and then her sister's boyfriend came and grabbed you, is that correct?
Yes.
And then what did he do to get you out of the apartment?
I believe she had me in a chokehold, and he just dragged me outside.
And then when you got outside the apartment, why did you wait for the police?
I believe if I left, I believe they would take it as me fleeing the scene, so I decided to just stay there.
Okay. And were you honest with the police officer about going into her apartment and things like that?
Yes, I was.
And I mean, do you understand that this would be scary for someone entering their house without them inviting them in?
Yes.
Okay. And how do you feel about that, the fact that you scared her?
I feel awful because then, even though I felt like I was wronged, she was still a good person, and she just never deserved what I did.
Okay. And I mean, are you willing to take all responsibility for what you've done? I mean, if you, this whole process, you've been pretty honest about what happened. Um, and are you willing to take, I mean, obviously understand that you're responsible for doing this. Are you willing to take full responsibility for that?
Yes, I do.
And are you asking the judge to put you on deferred adjudication today?
I would like to, but I would also understand the
Okay.
other option.
Okay. But if you're given the opportunity to stay out on probation, will you make the most of that opportunity?
Yes.
And what will you do to make the most of that opportunity?
I would first, if I do get deferred adjudication, I would try and attempt to get a job, pay my dues, and then pay the amount of debt that I have to my family.
Okay. And I'll pass witness at this time.
Any questions?
Yes, Your Honor, I believe you went into the facts of the case, so I can ask questions.
Yes.
Okay. Now, Mr. Lopez, you testified that you went to the victim's apartment that night, correct?
Yes.
Were you invited by her?
No.
So this was your choice? Okay. When you got to the apartment, you mentioned, actually, no, before that, you said that you had a key to that apartment, is that correct?
Yes, that was correct.
And you said you made that key with her permission?
Yes.
She knew the whole time you had a key to her apartment?
She didn't know, but I assumed,
She didn't know.
I guess, yes.
Okay, she didn't know you had a key to the apartment that you made on your own accord?
Yes.
Okay. And when you got to the apartment that day, it was your intention to use that key to enter the apartment, correct?
I did, but I decided not to.
You did not to, okay. So then you met her at the front door, correct?
Correct.
She opens the door because she's wanting to go about her day that day, right?
Correct.
And you forced your way in with her into the apartment, correct? You pushed her all the way to the back bedroom, correct? There was a scuffle the whole way from the door to the bedroom, correct?
Yes.
Are you aware that you hurt her physically?
I believe so. Yes.
Are you aware that you scared her substantially?
At the time I did not.
Well, it would be reasonable for someone in her position to be very scared from what you did to her, right? Okay. Now, you said that the last thing is that you're wanting to take responsibility for what you did,
Yes.
and you understand that responsibility could include going to prison?
Yes.
No further questions, Your Honor.
All right.
Just argument, Judge.
Well, I have some questions.
Sure.
All right, so about this key, you were saying that you assumed you had permission to copy the key?
Yes, because I still had it.
So why did you assume? I heard part of your testimony where you were saying, or correct me if I'm wrong, did you say that you went with her to make a copy of the key, but then something happened and you all couldn't do that?
Yeah, it was the day I came to San Antonio. She gave me the key and we both went to Walmart to go to the key thing, to copy the key, and it wasn't working. So we decided to just leave. And the next day I went to go make a copy of the key.
Okay. And then my other question. So before this happened, how was your relationship?
I would say it, in my opinion, it was good. Obviously, there were some arguments here and there, but like other than that,
Was there any prior violence?
no.
All right, any other questions?
No, Your Honor.
All right, so here's the thing. State is remaining silent, and I have to make a decision on whether or not I think prison is the right place for you. When I was in the DA's office, and I would have third chairs or second chairs sit with me, when we were looking at indicting cases, before I would take a case to the grand jury, I would do my own investigation. Because I tell my students this as well. This is your job, right? Hopefully the police are doing their job. They do a thorough investigation. And then the stopgap from somebody getting indicted, right, is the state is supposed to do their job, do their investigation. It's not supposed to be like, okay, the police said they did this. I've read the police report. It appears that they did this. So therefore I'm done. Let me just take this indictment. So whenever I was in the DA's office, what I would do is I would read a police report and look at all the facts in it. And then I would be curious. And I would always tell people, sometimes the questions you have nothing to do with the price of peaches, but then sometimes you may see that, hey, this has to do with the price of peaches, and these are questions that need to be asked. And then my next thing would be is I would then reach out to attorneys and I would say, hey, this is what I would be willing to offer in this case, because I would speak to persons who were sitting with me. I said, okay, we've done our investigation. We believe that this person has committed an offense beyond a reasonable doubt. Then your job as a prosecutor, because you're supposed to be doing justice, that's what's in the code. Prosecutors are not to seek convictions, they're to do justice, right? So then I would ask the person sitting with me, I said, your next question before you even consider taking it to the grand jury, what is the end game? What do you think is justice? Do you think this person should go to prison, or do you think they should have probation? If I felt they should have probation, I would reach out to the defense attorney if they had one at that time and say, hey, I've done the investigation on this. Think this person should have probation? Are they willing to come to an agreement? And then sometimes I would say, hey, this person deserves to have prison. I would reach out to the attorney. This is what I'm offering. And whatever I offered, if I was saying the offer is 5 years prison, if somebody would end up going to jury trial, and sometimes people would get upset with me, they go to jury trial and they would be found guilty. And you know what I'd do? I'd stand before the jury during punishment and I would ask for 5 years, because that's what the cases were. I would never do this thing where, okay, you want a trial? You go into trial? Fine. I'm no longer offering 5. I'm going to ask this jury for life, because to me, the case is worth what it is worth, for want of a better term. So in your situation, I don't have a crystal ball, right? I understand that you're young, pardon the expression, dumb, in a new relationship, driving all the way from College Station because you believe the person that you're in love with was unfaithful to you. And I try to tell young people, all of these relationships, some of them will last forever. Some of them are crazy, like Romeo and Juliet. I never understood in my school why people were gaga over Romeo and Juliet. I'm like, this is some stupid nonsense where they're killing each other because they're in love. And then when I did my research and discovered how old they were, I was like, oh my gosh, didn't their parents say anything about this relationship? So my question is whether or not, for me, is whether or not you should go to prison. The state is silent. So the state is not telling me yes to prison or no to prison. So I got to figure that out, right? And this is what I am going to do. He's saying that there has been no previous violence in this relationship. So that's what I have to go with, because I don't have any other evidence before me that suggests something differently. So here's your choices. These are the only choices you have. Don't come to me with a separate choice. People say that in my court, probation is very difficult. I try to give people the tools they need to be rehabilitated so they won't be back before another court, or that I'm passing the problem off to society. So you have a choice. Your choice is I can send you to prison for 2 years, or I can place you on probation, and I'll place you on probation for 8 years, and that's deferred adjudication. Those are your two choices.
I would go for probation.
All right. So, and here's the thing with that. I've seen a lot of cases that have come before me, some cases that are worse than yours. Sometimes people are offered deferred for cases, and I don't understand why they were offered deferred. But this is where we are. So this is what the court is going to do. The court is going to sentence you to 8 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs. There's to be no contact with the complainant. That relationship is over. You don't have any children together. You don't have any property together. There's no need to call her. There's no reason to text her. If accidentally you receive a text message from her or phone call, that number should then be blocked. You understand?
Yes, ma'am.
It's over. And don't get into any other relationships until you work on yourself. Because the fact that somebody may be unfaithful to you or somebody doesn't want to be in relationship with you anymore shouldn't send you into a spiral. There is to be 200 hours of community service restitution, proof of employment within 30 days, no employment as a home health care provider or with minors. And then if he obtains a higher level of education or trade school certificate, the community service hours will be deemed satisfied. Let's see what else is here. There's a $1,500 fine that will be probated. Probation, is there anything else?
Bill visits judge and possibly anger management.
Thank you. Field visits 1 time per month for 6 months. Anger management. And is he currently in Bear County?
No, Judge, right now he's residing in Bryan, is that still correct?
Yes.
But it's your intention to move to your father's house, is that correct, or? are you planning-
If I, yes, in my father's house.
And that's in Brownsville, Texas?
Yes.
And which county is that?
I believe it's Cameron County.
All right, so are you in Bryan for school or something?
Yeah, I was going to Wayne College.
He was going to school, Your Honor, but then what happened is because he picked up these charges, he couldn't proceed with that program because of his arrest. But his intention to roll, I talked to him earlier today, it's his intention to re-enroll in school. And I think he also wants to get a job at the same time, so.
All right, well, they won't do, you don't need a transfer, I don't think, to attend college. So the court will do anger management, a transfer to Brownsville with his father, and he's allowed to attend college. Your client needs to fill out that.
Thank you.
Anything, I know you're silent, but are there any other conditions you would request?
Maybe a tap eval and
All right, tap
just to get
evaluation.
that.
All right, thank you. Tap evaluation out of custody, follow recommendations. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. You better start making better choices. And let me explain something to you. The state was offering you a cap of 5 salary. You decided to do deferred adjudication. From here on out, everything you do, you need to ask yourself, could this result in me potentially going to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. So you had your liability limited to 5 years. Now your liability is potentially 20 years in the prison. Do you understand?
Yes, ma'am.
All right, good luck to you. Is there,
Victim impact statement. Yes,
all right,
ma'am.
if you just stand over there.
Yeah, I just want to verify with the plea bargain.
Who's here on Jacob Jesus Leal? Thank you so much. It's one of those days.
Thank you. Make sure you speak loud enough for the recorder. Okay, you said.
And his cases still have not been indicted, correct?
Correct, Your Honor.
Have you spoken with the state?
I have, Your Honor.
So did they give you, okay, did they give you an idea?
They weren't, they asked me to request that it be sent to grand jury, that they're not sure. 3 of the 4 cases are victim cases that they'll have to reach out, and then one of the cases is still pending labs.
All right. All right, so what's gonna end up happening? Who's the prosecutor on this?
I spoke to Ms. Galloway.
All right. Oh, Ms. Galloway, so in this case, there are not gonna be any more settings in court until it's indicted.
Okay, thank you, Judge.
All right, thank you.
Mr. Banks is the intake prosecutor and he is in the process of collecting the evidence. And I did double check on that. So thank
All
you.
right. So the next time you'll be in court will be if these cases are indicted and you'll receive a card in the mail. You need to make sure that your appropriate and proper address is on file. Otherwise, it's going to be sent somewhere else. And a warrant's probably going to be issued for your arrest if you don't show. You understand?
Yes, ma'am.
All right, thank you.
Yes, ma'am.
Thank you, Judge. Okay. Well, tell him he's gonna go to trial in his. All right, how are you? Oh, thank you. All right, Camaria, who is that? Hi, how old are you? All right, so there are consequences for choices. When a jury comes up this afternoon, you're gonna be in trial in those clothes since you didn't want to dress.
Judge. Sorry, is that Renee Kimberly?
Yes.
Who's gonna be?
I'm sorry.
It's gonna be.
Okay, all right, thank you. See, Jason, I'm trying to teach 18-year-olds there are consequences for action. All right, who's here on Tiffany Martinez? All right, so she's scheduled for jury trial today.
Yes,
All right, 1:30.
we're not ready. We do have a motion to continuance on file.
All right, Jill, if you can have them pull the motion for me. And then I'll take you up.
Okay.
Who's here on Jalissa Cerniel? All right, Jonathan De Hoyos.
Order, Your Honor.
Good morning.
Sean Brown from Mr. De Hoyos, we're ready.
All right, is this an application?
It is for deferred recommendation.
All right, probation, this is an application. Where's your client?
Yes. Coming up.
Nobody wants to approach with their attorneys anymore. What's going on?
I guess he wants me to take the deal and be on probation for 6 years.
All right, that could be it. That's it. Way to go. All right, court is calling 2025 CR 003498 State versus Jonathan De Hoyos. Could I have parties announced?
Jason Gearham for the state, Your Honor.
Sean Brown from Mr. De Hoyos, Your Honor.
And are you Mr. De Hoyos? Counsel, have you received all discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. De Hoyos, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
I believe we are, Judge. Okay, thank you.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with evading arrest detention in a vehicle as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is, Your Honor.
Mr. De Hoyos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes,
According to the plea, punishment is to be assessed at a $2,000 fine. State recommends deferred adjudication. This is to be run concurrently with the case from Guadalupe County, and it's case number 2313990CRC. Did you understand that to be the plea?
Yes, ma'am.
Defense,
That is our agreement. Yes, ma'am.
state?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Excuse me, Your Honor?
Have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 6 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? You need to speak up.
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State Exhibit number 1 with all its attachments.
Judge, I've reviewed that with my client. We have no objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We'd ask to waive the PSI, Your Honor.
All right, anything you wish to say on behalf of your client?
Judge, he accepts responsibility. Obviously, we're here today. He's working. He lives with his family. He's got a good support system, understands he made a terrible mistake and choice, and we're asking him to follow the agreement that we have with the state.
All right, how old are you?
23.
All right, why are you doing this?
It was a bad decision.
Why are you making bad decisions that could perhaps result in your death and other people's death?
Hanging out with bad people.
Now, if I talk to the person who was the passenger in the vehicle, if he were before me charged with this offense, which he can't be because he wasn't driving, but if he were charged with this offense, you know what he'd say? I was hanging around with bad people, and I'd say, well, who are these bad people? And you know what he would say? You are. And in the big scheme of things, you're the one who was driving. Did he have a gun on you making you drive? So you're the bad person, right? You still have a chance to change your ways. How did you get to court today?
Truck.
I'm sorry?
My truck.
All right, so what I can tell you right now, today is the last day you're gonna be driving that truck. You know why? Because as a condition of your probation, I'm not gonna allow you to drive until you complete the defensive driving course. Do you understand?
Yes, ma'am.
And after all of this happened, you live with your parents?
Yes.
They didn't take the keys to your vehicle and say you're not allowed to drive because you're not responsible? So I'm gonna do it. All right. Are you employed?
Yes, ma'am.
What do you do?
Auto detailing.
All right, you're gonna have to take the via bus or get an Uber because you're not allowed to drive. Do you understand?
Yes.
Use words, okay,
And Judge, that's until he takes the definitive driving class and provides certificate to probation.
yes.
Okay, thank you.
And there's gonna be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. And when you're drug tested today, what are the results gonna be?
Positive
For what?
for no drugs.
I'm sorry, what?
For no drugs.
Just alcohol, he said.
Oh, just alcohol?
I don't do any alcohol.
Well, I mean, what are you gonna be positive for? Speak
Mayor,
now, forever
we're
hold your
elected.
peace, because you will be tested today. So what is it gonna be? If you use earlier this morning, if you use before I'm placing you on probation, that's not a violation of your probation. If you use after, it's a violation. So what are you gonna be positive for? Your attorney wasn't with you using drugs. You were with whomever you were with. He doesn't know. So what are you gonna be positive for?
I mean, not down, drink or smoke or anything like that.
So you're saying when I send you to go do a UA, you're gonna not be positive for any drugs? You need to use words.
No.
So you're gonna be negative. All right, I'm gonna want a UA today. And if the UA is positive, what's gonna end up happening is you're gonna go into custody, and you're gonna do a TAP evaluation in custody. You understand? All right, so there's to be a UA today. If he's positive, then you'll report back, well, you're gonna have to report back to court anyway. So if you're gonna be positive from the testing, you need to make sure that your parents or somebody can pick up your truck for you. You understand? So there's a UA today. No later than 1 p.m. There's to be the defensive driving course. A 100 hours of community service restitution. If you obtain some sort of trade school certificate or higher level of education, the community service hours will be deemed satisfied. There's to be no contact with I saw his name.
Gilbert Lotta, Your Honor.
Thank you. There's to be no contact. Thank you. With Gilbert Lara. Field visits 1 time per month for 6 months. And it is to be a $2,000 fine. That will be probated concurrent with case out of Guadalupe County, number 231390 CR. They're asking for 6 years deferred adjudication. You want to speak to that?
Yeah, Judge, I would ask that he get the 4. I think 4 would be sufficient under the circumstances of this charge.
All right, 4 years deferred adjudication.
Thank you, Your Honor.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, in just 1 moment. There's to be a TAP evaluation out of custody if the defendant tests negative. If positive, then the TAP evaluation will be in custody. And there's to be no driving after June 10th, 2025 at 5 p.m. All right, I'm sorry. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You can't be racing through the city like this Fast and Furious, because even that, when they have controlled movement, people still are injured, and you're not a professional. You could have killed anybody. Your passenger could have been killed. And if your passenger would have been killed, you know what? The state would have been looking to file charges. You understand?
Yes, ma'am.
Or I should say, receiving charges from the police. And this would have been more than just an evading arrest and detention in a vehicle. All right, good luck to you.
Thank you, Judge. May I be excused?
Yes.
Thank you.
All right, James Weed. No, I'll do it. All right, thank you. All right, Tiffany Martinez.
Used my full name, it kind of scared me.
James Weed.
Yes. Put the middle name in there, I'm in real trouble.
All the way up here to the left line, make sure you speak loud enough for the court reporter to hear you.
All right, who's the prosecutor on this? All right, the court is calling 2024 CR 008238 State versus Tiffany Martinez. Could I have parties announced?
Jason Gearhand for the state, Your Honor.
Jim Wheat for the defense.
And are you I'm sorry, and are you Miss Martinez?
Yes, ma'am.
All right, you're scheduled for jury trial today. Defense, you filed a motion for continuance?
I have to.
Yes. And
Yes.
what is the reason?
It is something at this point, we are looking into the relationship between the 2 co-defendants further. Information has come up over the last week that I need to go into further just to get the not just her thoughts on it, but also outside resources.
All right, and State, do you have an objection to the motion for continuance?
No, Your Honor.
All right. All right, the motion for continuance will be granted. And then what we will do you have an idea of what's a good setting for you all to agree on, a setting for jury trial?
On this one,
Mhm.
I don't know.
All right, so then council, what I'll need you to do is I'm gonna either need you to zoom in. The coordinator had a meeting that they had to attend. Well, you know.
Can I
what?
email her?
No,
Is that
this is
all
what I'll do. So you can leave. I'm gonna set this for a date. And then that will give you a chance to look into what you need to look into.
Okay.
And then this will be the date that you come back to get your jury trial setting. All right, thank you. All right, so I'm gonna have you come back on July 21st.
Okay.
And that will be at 9 a.m. And it will be to obtain a trial setting.
Okay.
All right, once you sign the reset form, bring it back to me, please.
Thank you, Judge.
Thank you. All right, Marco Marino. And council, we'll just put on the record his finances, so there's no need to discuss the motion. I just need his finances for the record. Court is calling 2024 CR 006824 State versus Marco Marino. Can you raise your right hand for me, please? I'm sorry. Defense, state your name for the record.
Christine Brown on behalf of Marco Moreno.
And state you're not needed for this hearing. And are you Marco Marino? Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. State your name for the record.
Marco Moreno.
All right, when's the last time you were employed?
I believe it's March 11th.
All right. And do you have any bank accounts,
I do.
any savings in your bank account?
No.
So they're keeping it open even though you don't have any money?
I think I still have. I'm not sure.
All right. The last time you reviewed your account, how much money approximately would you say you had in your account?
It's less than 50.
All right. And has there been any family members who put money on your commissary?
My mom and family.
All right. Do you currently have money on your commissary account?
I don't know. I don't know.
All right. The last time you checked, how much money did you have on your commissary account?
56 cents.
All right. All right. Thank you.
Thank you.
Yeah. All right. Thank you. Deputy Laura, we're finished with Mr. Marino. And they'll give you a copy of this in the back.
Okay. What is the ruling?
Oh, I'm granting it.
Okay.
Yes,
Okay, thank you.
sure. All right, who's here on Barry? Marquise Barry. And is there an application?
Yeah.
Court is calling 2023 CR 3465 State versus Marquise Trayvon Barry. Can I have parties announced?
Megan Galloway for the state.
Angela Blake, attorney for Mr. Barry.
And are you Mr. Barry?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Barry, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, we move to proceed on the lesser included offense of possession of marijuana, 2 ounces to 4 ounces, the class A misdemeanor.
Any objections?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand the state is proceeding on the lesser included offense of possession of marijuana, 2 ounces to 4 ounces as a class A misdemeanor? Range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Berry, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense. They're asking that your punishment be assessed at 18 days in the Bexar County Jail. There's a $500 fine. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions? Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State offer states one in attachment.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We ask for time search, Your Honor.
All right, the court will find you guilty, sentence you to 18 days in the Bexar County Jail. Give you, there's a $500 fine, time and money to rank concurrent. And the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Do you have any children?
Yes, ma'am. I have 2 and 1 on the way.
All right, and what are their ages?
3-year-old and 9-year-old.
All right, so let me just tell you this, a 3-year-old and a 9-year-old should not be driving around in a vehicle that smells like marijuana. Now, your 3-year-old and 9-year-old, do you love them?
Very much.
How much do you love them?
Everything in me.
All right, so how long have you been in jail?
About a week now.
All right, so is marijuana worth you spending a week away from your children? So you're gonna have to make changes. And before you transport them around in your vehicle, you need to take that vehicle, have it detailed. It'll probably cost $365. Have it detailed and have that scent removed because their brains are steadily growing and you don't want it to be impacted by marijuana smells, right? And you don't want the 9-year-old feeling embarrassed if people at school know that his father is using marijuana because children know what it smells like. And I know people say marijuana is no big deal, but in Texas, it's still against the law unless you have a prescription. Do you understand?
Yes, ma'am.
Now, when you're released from jail, if you need anything, if you can't kick using marijuana, if you come back here and I'm here, I'll help you find a place that can help you. All right?
Yes, ma'am.
All right, good luck to you.
Thanks, Judge.
Who's here on Chase Lopez? So
Hello, Your Honor. I was gonna say good morning, but I think we just
Oh, yeah.
passed that.
we have passed that. So many things happened today.
Yes.
All right, so where are we on discovery?
I believe that we have all of the discovery. I'm double checking with the medical records that the state has, just double checking they're the same that have been uploaded. We have conferred and received an offer. We'd like some more time. As you can see, my client is a little on the younger side, and
Mhm.
so we'd like to really weigh the options of the offer that the state has given us against the evidence and risks associated with trial. So if we could get 30 days, Your Honor, that would be wonderful.
Okay, how old are you, sir? All right. See, now, when we say that other people are younger, that, I don't know, that's saying something about my age.
Yeah.
As we get older, when you're in your twenties, you think somebody in their sixties, oh my gosh, that's all. But then as you approach that, you're like, no, 60 is not all, yeah.
I take it back. Yeah, no.
All right, so what I will do is I'll recall you for July 29th.
29th? Yes, Your Honor.
And that will be your plea deadline date. So once you sign the reset form, you can be excused. And I will give you a copy of the reset to sign, and then just return it back to me, please.
Understood.
Good morning.
Sure.
Yeah, good afternoon. Yeah, we're gonna be here, and then once lunch arrives for the jurors, we're gonna take our recess.
Sounds good.
All right, so you were recently appointed.
Yes, this is our first appearance.
No gum chewing. I would love to be chewing gum right now.
This is our first appearance, Judge. I'm working on discovery, and we will see what we can do next setting.
All right, I'll set this for discovery. June 22nd, I'm sorry, July 22nd. Is that good for you?
That's beautiful.
All right, I'm gonna give you the reset form, and once you sign the reset form, please return it to the court.
We will do that, Judge.
And counsel, did you get on his case that is the first degree? It's a PF case.
Yes.
All right. And we'll just set it for discovery, counsel.
Okay. Thank you, Judge. Return that.
All right, thank you. All right, who is here on Dina Acosta? All right, are you all ready to proceed with sentencing?
We are, Judge.
I'm sorry, just 1 second. Do you need a copy?
Oh, no, Your Honor, I didn't. I just wanted to make sure you knew before we could be excused.
Oh, yes, you can be excused.
All right,
so
thank you, Your
much.
Honor. All right, you'll have a good one.
All right, the court is calling 2024 CR 0075332 State versus Dino Acosta. Could I have parties announced?
Jason Gearhead of the state, Your Honor.
Scott Simpson from Mr. Acosta.
And are you Mr. Acosta?
Yes, ma'am, I am.
All right, we're here for sentencing. The court ordered that half of the restitution be paid before sentencing. So has that been completed?
We have, I believe the court got a copy of it too. This is my client's copy.
Sure.
He paid $8,000 today. Andrew signed off on it.
Okay,
So that was the amount that was in the plea, 8,000 of the 16,500.
okay.
And it has been paid. He still owes 8,500. He knows that, which is part of our argument as to, because it's an opposed plea, Judge. So that's part of our argument as to why you should grant probation.
All right, so the total restitution is 16,500, but he paid 8,000 of that, correct?
That is correct, Your Honor.
All right. I saw where you had wrote on that form that he owes 10,000. I'm like, is my math off?
That's for us.
Okay. Oh, sorry.
We
Yeah.
haven't been asking him to pay us because we wanted the restitution.
Excuse me, Mr. Green, is Mr. Green here? You know, that was from, well, you know what movie I'm talking about. Okay.
I do.
All right, let me find the plea bargain agreement. All right, you entered a plea, and according to your plea bargain agreement, the state is opposed to your application. And restitution was to be to Andy Hydrick and Rocky Hill Equipment Rentals. And there's to be a $2,000 fine. State, he's made an $8,000 payment. Are you still opposed?
No, Judge, in lieu of the fact that he made $8,000 and showing improvement on that, the state would be recommending a probation there period.
All right, are you recommending the deferred? Because he's requesting deferred.
A good conscience, I can't recommend deferred on this, Judge. The reason being is just because of the history.
We applied for both, Judge, and just an abundance of caution. He does have felony convictions already. I do need, it's, the person that is owed the restitution is Hector Gabaldon. With the equipment that was stolen, was received back by the aforementioned people that you talked about. It just, he sold it to Hector, and the Hector had to return it to those people.
All right,
So Hector's the person getting the restitution.
okay. All right, this is what the court will do. The court is finding you guilty. The court will sentence you to 10 years in the prison, suspended and probated for 8 years. There's a $2,000 fine that will be probated. There's to be restitution, if any, to Rocky Hill Equipment Rentals. Is that the appropriate person, counsel?
Put that down just in case, but they already said they didn't have restitution, but then we need to add Hector. And the last name is spelled Gabaldon. He's the one who's actually out money, Hector Gabaldon.
Right, so Andy Hydrick is not owed any money?
No, they got their equipment back, from what I thought.
That's the individual, I believe, with Rocky Hills, Judge.
Okay. All right, so I put down Rocky Hill Equipment Rental, so if something pops up, then it will still end up going to the owner, Andy Hendrick.
Thanks, Judge.
So the court will note that the defendant has paid a total of $8,000 upfront. Could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Acosta?
All right, so Mr. Acosta, based upon the restitution amount, at sentencing, I was told that restitution amount was $16,500.
Correct.
So you paid the $8,000, so what's due is $8,500. How much are you able to pay per month towards the restitution?
I could do anywhere between $1,000, if that is.
All right, so here's the
sufficient.
thing. This is what I tell people. I just want to know what the amount is, and whatever you say the amount is. Of course, if you tell me $20 a month, I'm going to say absolutely not. But whatever the amount is, that's what I'm going to put in this order. So if it's $1,000 and you're 100% sure that it's going to be $1,000, then I'm going to order you to pay $1,000 a month towards restitution.
Understood. Well, in that case, $500 would be sufficient. That way I meet up to my expectations.
All right, he's to pay restitution in the amount of $500 per month. Proof of employment within 30 days, no employment as a home health care provider or with minors. There's to be the theft course, a $2,000 fine that will be probated. Field visits 1 time per month for 3 months. 200 hours of community service restitution. Regular reporting by Zoom or in person, and regular random UAs. Probation, is there anything else he needs?
Yes, Judge. So as far as the restitution, the Rocky Hills Equipment Rental, according to the PSI, they're not requesting any type of restitution. Also, Mr. Acosta indicates, and I think the court is aware that he travels for work. I just need something to put in his conditions, giving him permission for that.
He works as a welder out on one of those deep sea rigs.
All right, so I'll put, the defendant is allowed to travel for work. And then there's no restitution then to Rocky Hill Equipment. So the only restitution will be to Hector Galbaldo.
And Judge, I just wanna confirm, Mr. Acosta, when he does travel for work, he goes everywhere and he's gone for an extended amount of time. Is it okay that I make sure that that's in there?
Yes. Is there anything else?
Nothing further from the defense, Your Honor.
Anything else you need from the court?
I just want to say thank you for the opportunity. I know I did make a mistake, a bad decision. I don't want to call it a mistake. It was the decision that I made, and it was a bad decision overall, and I'm paying for the consequences, set my family back. But we're looking to do better, And I do want to say thank you to the state as well for giving us this opportunity, even though we were purpose.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, I did.
All right, do better.
Yes, ma'am.
Thank you,
Very well.
everyone.
Thank you,
Thank
Mr.
you.
White. You have a good day.
Who is here on Marcus Butler? All right, counsel. What is happening with Mr. Butler?
Yes, please.
The state has given me all the discovery in this case, Judge. I have an appointment with him this Friday to go over everything.
Okay. All right, how old are you, Mr. Butler?
I am 46 years old.
All right, I'm gonna set his plea deadline date for July 22nd. Let me give you a reset form. Once you sign it, bring it back to the court. All right, who's here on Curtis Wilson? All right, where's Mr. Wilson?
State tells me he has left the building.
All right, so I'm gonna issue a warrant for his arrest.
Judge, I'm asking that he be remanded without bond.
I'm gonna issue a judge's warrant and remand him without bond. And we're gonna go on the record. Court is calling 2024 CR 2927B, 2024 CR 2928B, 2024 CR 3099, State versus Curtis Wilson. Can I have parties announced?
Megan Galloway for the state.
Blood written hour for Mr. Wilson.
All right, this hearing is scheduled at 9 a.m. I did notate that I saw Mr. Wilson in the courtroom. Did he show up for court today, counsel?
He did, Judge.
All right. And Deputy, could you make an announcement for Curtis Wilson in the hallway, please? All right, thank you. All right, defense, do you know where your client is?
Do not, Your Honor.
All right, state.
Your Honor, I'm asking that the court issue a judge's warrant and remand the defendant without bond.
All right, the court will issue a judge's warrant in each cause number and remand your client without bond. And the court did today receive a violation report. Counsel, have you had a chance to review that?
Given to us about an hour ago, Judge.
All right. All right, thank you.
Thank you, Judge.
Sure. All right, and Adriana? Yes, ma'am. I gave you Mr. Wilson's file, because those are warrants
Yes,
that need to be issued immediately.
Yes.
All right, thank you. Who's here on Mason, Washington?
All the way up to the black line, make sure you speak loud enough for the court reporter to hear you.
Your Honor. May I just say one
Yes.
thing before we start? Your Honor, due to the nature of the charge, my client is asking if maybe we could be a little more quiet
Sure.
when it's read out.
So, did he enter a plea or no?
Previously, we did not get through the plea, Your Honor, but we've received a different offer then.
So, are you all going to be accepting the plea or no?
Yes, Your Honor.
All right, so have you already filled out the paperwork?
Yes, Your Honor.
I don't have the paperwork for this.
I did just hand it to,
Just handed it to me.
yes.
You didn't tell me, I had 3 other keys in front of me.
Oh,
I didn't know, I'm so sorry.
no problem.
So this
Sorry,
is.
sorry.
No problem. We'll get to it, just have to see
Thank you
it.
so much.
Partner gets back. Yes.
Here on Tyrell Benjamin. Who's the attorney for Tyrell Benjamin? All right.
Judge, we, I've been conferring with the DA's office about a potential offer change and, we didn't get the offer change that I was looking for. So we'd like a reset today, so potentially we can take a plea next setting.
All right.
And, previous date that I had from you was July 22nd.
All right, that's gonna be your plea deadline today, although today was supposed to be for disposition, but since a new offer has been tendered, this case will be resolved on that date, either with an agreement being reached or either a jury trial. You understand?
Yes, sir.
All right. All right, once you sign that,
I'll get it back to you.
thank you.
Thank
Thank you. You're welcome. Thank you for dressing appropriately for court. Who is here on Jamarian Greer?
I'm here, Your Honor. Your Honor, once again, good afternoon. I was conferring with the state, they've given us a new offer. We're considering that new offer and or a jury trial potentially.
All right. Your plea deadline date is gonna be July 22nd, or either you're gonna be in trial. You understand? So this case will be resolved by that date. Oh, bring that back to me once you sign the paperwork, because I need to put it in the system.
That's there for you, Judge.
Who is here on Eddie Law Outlaw? Yes. All right, where's your client?
He discovered he has an at-large misdemeanor case that was filed. He's at the jail.
Well, I will tell you, I have him down for today, at least on my docket sheet. Let me double check. Yeah, but I don't know if he should be.
Mixed up in the shop. It's a sign from the university. This is.
Let me see.
Couple more.
Oh, no, it is today. All right, so where is he?
Bear County Jail.
Ah, okay. So today is plea deadline date. What we'll do is we'll have him recalled for Thursday.
Thursday.
All right.
Thank you.
Thank you, Judge.
All right.
Yeah, or just,
Oh, just make sure you're here, because is he planning on releasing?
that's the hope.
All right, so it'll be on the 12th, okay?
Thank you, Judge.
All right, thank you.
We just need to approach the judge on the plea offer that was made.
All right, Carlos Saldana. All right, and he only has one case?
Yes, Your Honor.
All right, so what is happening with this case?
Judge, I believe the defense counsel had a plea worked out, but I don't believe that the defendant wants to take the plea any longer.
We'll go on record, Judge.
Sure. Court is calling 2025 CR 003338 State versus Carlos Saldana. Can I have parties announced for the record, State?
Jason Garahan, Your Honor.
Roberto Lars for a defendant. Just to refer,
Just 1 second. Are you Mr. Saldana?
Yes,
We have an interpreter here. Can you raise your right hand for me, please? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Carmen Tarragona Sáez.
Thank you. There's something you want to say, counsel?
yes, Judge, just to refresh the court's memory, at the last setting, they had made a reasonable, very reasonable plea offer, but we didn't have a Padilla letter, so we reset it for a Padilla letter. Having done the Padilla letter, you cannot go forward with the plea offer and ask for jury trial.
All right, so he'll go to a jury trial. So I'll see you back here this afternoon.
Judge, not prepared today. Today was not set for plea, it wasn't set for a trial.
No, this was set, and then you were in trial somewhere else. And then it was reset, I mean, it was set in May. And then you were in trial somewhere else. Then it was set yesterday, and you were in federal court, and now we're here. It's a possession less than a gram case. So we'll see you at trial this afternoon.
Okay.
All right, thank you.
Thank you.
And counsel, he can do a jury trial or bench trial, whichever you prefer. Or he prefers, I should say.
Your Honor, may I beg to?
Yes, thank you. All right, Roger Mims? Yes. All right, jurors scheduled for jury trial. All right, so we'll have you all here tomorrow at 1:30. Yes, because we're still waiting for this jury to finish their deliberations. But they're not coming to the court for punishment if he were found guilty. I'm sorry, they're not going to the jury for punishment if he were to be found guilty, so there'll be no issues.
Judge, there were. I don't know if we'd like to hear about it today. or
Sure.
tomorrow. There were a couple of issues. One kind of involves the state. I know that the court probably does not care which defendant gets tried first, but I know that they had an interest in not trying Mr. Mims' case first, which is a state issue, not a court issue. My particular issue, and I've not yet filed a request for this, is part of the substance of his indictment involves a civil protective order
Okay.
that I, one, feel I may be lacking recovery on, or two, would like to look into a little more closely. I've never addressed this issue in an indictment before.
Okay.
So to that end, I don't mind requesting a continuance of the court this afternoon. The court would like me to, or to wait until tomorrow.
Yeah, I'll see y'all tomorrow.
Tomorrow.
Yes, once you sign the reset form, just turn the reset form back into me and then you'll be excused. All right, thank you.
Ma'am.
And counsel, if you're requesting a jury trial, you need to, I mean, if you're requesting a continuance, court will need a motion.
Yes, ma'am.
All right, thank you. Rick, are you able to stand in for this plea?
Sure, it took me a second. I think that's an opportunity.
Yes. All right, the court is calling 2025 CR 0048180 State versus Diana LeCompte. Could I have parties announce?
Rick Pena for the state of Texas.
Nick Aguilar on behalf of the Honorable Diana LeCompte.
And how do you pronounce your last name? LeCompte. All right, there's no, all right, you're not Jordan? She's not from Louisiana, okay.
Well, she says she is.
Oh, yeah.
It's not the correct pronunciation. What is your family doing?
He's over there.
Mom, come on, Mom. Teach you, you have to teach, oh, no, don't come forward. Yeah. You gotta teach your daughter better with the pronunciations. No. Yeah, let me just tell you, we're off the record.
How should I pronounce it from now on?
Put that accent over that E. All right, so we're back on the record. Counsel, have you received all the discovery in this case?
Yes, Your Honor.
And did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. And is there an application in this case?
Yes, Your Honor. This should be up there. I found it in my notes.
All right. Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State you're proceeding on the indictment as presented, correct?
Yes, Your Honor.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand your charge of possession of a controlled substance penalty group 1 gram to 4 grams as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with, why are you putting citizenship Louisiana on this paper?
That, I always do that, Judge, just so the judge knows I asked. Always put in state.
Okay, all right.
When you see that, you'll see it on all my, I always make a note there so they know I asked.
Oh, okay. I was like, are you just doing that?
Another country. Lafayette.
Lafayette, okay.
You know where that's at.
All right. Did you understand by entering this plea, the court does not have to follow your plea bargain agreement? If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand that the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Very much so, yes.
Do you believe she's currently competent and is legally sane at the time of the offense?
Yes, Judge.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
Okay. According to the plea, punishment is to be assessed at a $2,000 fine. The state is recommending deferred adjudication, and there's to be restitution for drug testing. Did you understand that to be the plea?
Maybe.
Oh, well, let me go over it. So, according to your plea bargain agreement, there's a $2,000 fine.
Yes.
The state is recommending that you be placed on a form of probation that's called deferred adjudication. Did you understand that?
Yes.
And they're asking for restitution, and the restitution is supposed to be for the drug testing. Do you understand?
Yes.
They don't have an amount for the drug testing because it's not in the police report how much it costs to test the drugs. Do you understand that to be your plea?
Yes.
Defense, is that the plea?
Yes, sir.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, were there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and 150 hours of community service restitution. Did you understand that was a recommendation from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. At this time, state offers into evidence, state exhibit 1 with all attachments.
All right, state, you may be excused.
Thank you, Your Honor.
Judge, we have no.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. All right, proceeding with sentencing.
If you would consider that this afternoon, Judge, yes.
All right, anything you wish to say on behalf of your client?
Judge, Diana was in an abusive relationship. She admits that she did one of the drugs in her stock. She tells me she was self-medicating to help her through the relationship she was in. It's never been in trouble before that I'm aware of. So it took a bit to get through to understand the deferred concept, or deferred adjudication supervision concept. But she would like you to consider granting her the deferred adjudication for a period of 4 years.
All right, are you employed?
Yes.
What do you do?
I'm a sales agent.
And what are you selling?
Spectrum. Spectrum.
Spectrum. Okay. Spectrum does keep going up on their prices. Nobody knows. They get you in with the contract and then prices rise. So I've heard. How long you been working there?
I just started, it's my 4th week.
The last time we were here in Florida, we got out of here quick so that you could get her orientation that was.
All right. And how many children do you have?
3,
What are their ages?
25, 22, and 17.
All right. And do they still live with you?
No,
Okay. Where's the 17-year-old? Who's he with?
he's with his dad.
Okay. And if you're drug tested today, what are the results going to be?
I'll pass.
Hmm?
I'll pass.
When's the last time you used?
2024.
Okay. All right, this is what the court is going to do. There's a $2,000 fine that will be probated. 4 years deferred adjudication. 150 hours of community service restitution. And you know what? Even though he's 17, I'm going to ask for the parenting classes. You can never go wrong with the parenting class. Once you complete, complete the parenting classes, the 150 hours of community service restitution will be deemed satisfied. Now, if you don't want the parenting classes, your other option is to work in the Texas heat for 150 hours.
I don't mind classes either.
Okay. So there has to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. Do you have to go to work today?
Oh, it's, yes.
Okay. Then we'll do a UA tomorrow. There'll be field visits one time per month for 4 months. TAP evaluation, out of custody, follow TAP recommendations. If TAP recommends inpatient treatment, we can start with intensive outpatient treatment.
I did all that. No, I did
Hmm.
inpatient, I did outpatient. I
Oh,
said-
just give that information to them. Okay, but what the TAP evaluation is, it's just some questions you need to answer and they'll make a decision. They may say you don't need anything, all right? All right, probation, is there anything else? Is there anything else you need from the court in order to be successful?
Just a question, if I can take the UA today, that way I don't have to miss tomorrow too.
Sure, you can take a UA today. All right, anything else?
Will somebody give her guidance on where to take that?
Yes. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I understand.
All right, we can go off the record. In this court, communication is key to be successful on probation. If you have an issue, let your probation officer know. If you feel they're not addressing it, you can always come back to the court. All right? All right, good luck to you.
Thank you so
All right,
much.
you're welcome.
Thank you, Judge.
All right, bye-bye. Mick, you were great as far as the testing.
I think I'm gonna be fine today.
Yes,
Thank you, Judge.
you're welcome. All right, who's here on Jalen Zavala? Vashon, are you ready for this one? It's a probation application. All right, the court is calling 2024 CR 0126. I think this is one, let me see, the writing is faded, just 1 second. 012615, State versus Jalen Zavala. Can I have parties announce?
Yes, Jason Garrett here for the state, Your Honor.
Martha Crowe.
And are you Ms. Zavala?
Yes.
Counsel, have you received all discovery? Did you review it with your client? Court will find that the state is in compliance with discovery. Ms. Zavala, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on a lesser included DWI first, Class B misdemeanor.
Any objection?
No.
All right, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on driving while intoxicated as a Class B misdemeanor? Range of punishment is up to $2,000 fine and up to 180 days in the Bexar County Jail. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? You're gonna need to speak up so I can hear.
Yes.
Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Zavala, has anyone threatened, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen?
yes,
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes, ma'am.
According to the plea, the state is proceeding on the DWI first. Punishment is to be assessed at 180 days in the Bear County Jail. There's a $500 fine. State recommends community supervision. There's to be restitution to Adrian Harrison in the amount of $2,000. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
I know, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 100 hours community service restitution, and ignition interlock. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
No.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty of the lesser included offense. Are you proceeding with sentencing?
Yeah.
Anything you wish to say on behalf of your client? All right, are you employed?
Yes.
What do you do?
I set appointments for vacations. It's called resort vacations.
Okay. And how many children do you have?
Just one.
And where is the child now?
I don't know, what is that?
And do you and the father live together?
Yes.
So what have you been doing since this incident happened? How have you changed your life?
Been working, staying home. Following my orders.
Mm-hmm.
As for pretrial drug testing every week. And yeah.
So how did you come to be in this place with driving?
I got dropped off.
And then, not today, I'm so sorry. That's my fault for not being clear. I'm talking about the incident when this happened. So how did this come to be that you have the child in the vehicle and you're intoxicated?
I'm sorry, I'm confused by the question.
All right, so according to this, you were driving a vehicle,
Mhm.
you were intoxicated. A child was in the vehicle with you.
Mhm.
How did all of that happen? Like, why were you drinking and driving with a child in the vehicle?
I was dropping off my friend home. I had asked his dad to watch him, but he was gonna end up leaving with his friend, so I had no choice but to take my son.
No, that's where you tell the friend, hey, I've been drinking. You're gonna have to find your own ride. Here's an Uber, or you're gonna have to spend the night here. And the reason why I want you to think about what you did is because anything could have happened. And I haven't done any research on this. My statistics professor will be very upset for me saying this because I haven't done the research. But usually what ends up happening when people get in an accident and they're intoxicated, passengers are always injured or either passengers die. Usually the person who's intoxicated, they're just fine. And you know what ends up happening? They come to court, They're crying, they're upset because either they killed their best friend who's in the vehicle with them, or either they killed somebody who's just trying to get home. You understand?
Yes, I understand.
So you're one of those people who cannot drink. Your attorney, how long have you been practicing? Like a long time, right?
Yes.
So this is what I can tell you. I don't think your attorney has ever represented anybody who was charged with DWI and they tell her, you know what, my intention was to drink to intoxication and to kill somebody or to hit somebody or to get pulled over for driving while intoxicated. That's one of the crimes where nobody intends for that to happen, but it ends up happening. So you're one of the people who cannot drink alcohol at all because you don't know when to stop. You understand?
Yes.
And while you're on this probation, you're not allowed to drink at all. You understand?
Yes, ma'am.
So have you been taking classes or doing anything?
Yes, I've been doing the AA meetings.
Mhm.
I'm still doing them.
All right. Are you enjoying the AA meetings, getting to know people and,
Yes.
okay. All right. This is what the court is going to do. There's a $500 fine that will be probated. 180 days in the Bexar County Jail, suspended and probated for 2 years. Regular reporting by Zoom or in person, regular random UAs, 100 hours of community service restitution. I'm going to order parenting classes. Once you complete the parenting classes, 50 of those hours will be deemed satisfied. The other 50 hours, I'm going to ask her to do 50 sober meetings in 50 days. And that will take care of the remaining community service hours. You understand?
Yes, ma'am.
There's going to be a TAP evaluation out of custody, follow recommendations. There's to be the ignition interlock state. How long did you want the ignition interlock?
As we have left it up to the court, but generally, we ask for half the term.
All right, I'll set the ignition interlock counsel at half the term. If she's doing well, I may change that.
So she's not operating a motor vehicle. She doesn't have one. Hers totaled in the accident. We can request a PAM in lieu of the ignition interlock.
All right.
And an affidavit of non-driving, I suppose.
All right. So it'll be probation, it'll be ignition interlock for half the term, or it'll be PAM for half the term with an affidavit of non-driving. Is there any vehicle at that home?
Just my son's dad.
All right, so it's gonna have to be ignition interlock on that vehicle.
On that vehicle, she has access to it.
Yes. All right, probation, it's gonna be ignition interlock for half the term because there's access to a vehicle at the home. And then y'all want to talk about this driver's license suspension? Minimum 90. Maximum 180.
The state will be requesting 90 days, Your Honor.
All right, so there's gonna be a driver's license suspension for 90 days. And there is to be restitution, if any, to Adrian. Oh, thank you, probation. I mean, thank you, state.
Yeah, just-
Adrian Harrison. All right, sure.
And can she be given credit for the 90 days that her license was already suspended? She did consent to that breath test and it came back 0.01, 0.02. Very good.
All right, there's to be restitution, if any, to Adrian Harrison of $2,000. DWI education course. And victim impact panel live. Probation, is there anything else? Well, they have this listed as restitution, if any, but both parties have agreed to $2,000.
Correct.
Is that correct?
That is correct, Judge.
All right, so both have agreed to 2,000, even though they put if any.
Yeah.
But the most is $2,000 because that's what everybody's agreed to. But it could potentially end up being less. All right. Anything else? They've agreed to a total of $2,000.
And that's it.
That's it. But the person may end up giving you bills that are less than 2,000. So,
Still want to say
yes.
Nothing from
All right. Anything else you need from the court to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. So the reason why I said to them the $2,000 at the max, because sometimes people will turn in information and it end up being less than the 2,000. So, all right. Yes, proof of employment within 30 days, no employment as a home healthcare provider with minors. Do you think in this case we need field visits? What are you thinking?
I would say for at least 3 months.
All right, thank you. And then field visits 1 time per month for 3 months. Okay?
That's what that is.
Oh, that's where probation comes out to your house, just to make sure everything is going the way it should be, okay?
Okay.
All right, in this courtroom, to be successful on probation, communication is key. If you have an issue, let your probation officer know about it. If you feel they're not addressing it, you can come in and address it with me, okay?
Okay.
All right, good luck to you, all right?
Thank you.
You're welcome. Thanks, counsel. All right, who's here? Renee Camarillo? And is that a plea on 2 cases?
Yes, Judge.
And I'm assuming no applications.
Correct, Judge.
All right.
Still, they would still be requesting that we could have the formal sentencing next week. Due to victim impact, they're not available this week.
Okay.
If it's preferably Monday or Wednesday, Tuesdays really busy.
All right.
Next week, preferably.
All right, the court is calling 2024 CR 5219 and 2024 CR 5218, State versus Renee Camarillo. Can I have parties announce?
Jason Garahan for the state, Your Honor.
Marissa Giovanco for Mr. Camarillo.
And are you Mr. Camarillo? Counsel, in each of the cause numbers, have you received all discovery and did you review it with your client?
I believe I have and I did.
In each of the cause numbers, the court will find that the state is in compliance with discovery. In each of the cause numbers, Mr. Camarillo, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, in each of the cause numbers, do you waive the reading of the indictment?
I do, Judge.
State, and the cause number ending in 19, are you proceeding on the indictment as presented?
And Judge, I believe that's the felony murder.
It's the aggravated robbery.
Okay, yes, Your Honor, we're proceeding on count 1 and count 2
Okay.
in that indictment.
And then in the cause number ending 218, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding with count 1, the murder charge, and waiving count 2 and count 3.
Any objections?
No, Judge.
In each of the cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
In the cause number ending in 19, you're charged with the offense of aggravated robbery in counts 1 and in count 2. In cause number ending in 18, you're charged with murder. In each of the cause numbers, the range of punishment for each of those offenses is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
In each of the cause numbers, you have a right to a jury trial. You have a right to remain silent. You have a right to have your attorney confront any witnesses that the state would call to testify against you. Do you understand?
Yes, ma'am.
All right, so do you understand by entering this plea, you're giving up your right to a jury trial?
Yes.
Do you understand by entering this plea, you're giving up your right to remain silent?
Well,
So,
yes.
for example, if you were to go to a jury trial, the state could not call you to testify. Do you understand?
Yes.
Right, because you're entering into a plea, you can be called as a witness because you're giving up your right to not be called or your right to remain silent. Do you understand?
Yes.
Okay. And do you understand you're also giving up your right to have the state call witnesses to seek to prove that you're guilty beyond a reasonable doubt? Do you understand that?
Yes, ma'am.
And so in doing that, you're giving up your right to have yourself or your attorney question any witnesses that the state would call. Do you understand?
Yes.
Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe so, yes.
Mr. Camarillo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a US citizen?
Yes, ma'am.
All right, in each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, did you review the plea bargain page with your attorney?
Yes.
Did you understand it?
Yes.
All right, in the cause number ending in 19, according to your plea, the state is proceeding on counts 1 and 2. They're asking that your punishment be assessed at 20 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. This case will run concurrently with 2024 CR 5218. And they are taking in consideration 2025 CC 005805. In the cause number ending in 19, the state is proceeding on count 1. They're asking that your punishment be assessed at 20 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. And this will run concurrent with 2024 CR 5219. Thank you. And they're taking in consideration 2025 CC 005805. Did you understand that to be the plea? So according to your plea bargain agreement, in each of these cause numbers, the state is requesting that you serve 20 years in the prison. Do you understand? And do you understand with a 20-year sentence and an affirmative finding of deadly weapon, you're not eligible for parole until 10 years are served flat, which means 10 years, day for day. Do you understand?
Yes, ma'am.
Did you understand that to be the entirety of your plea?
Yes, ma'am.
Defense,
Yes, Judge.
state?
It is, Your Honor.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are pretrial motions that your attorney has filed and that we've had hearings on, and I've made a ruling on those motions. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
Then in each cause number, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial and that the defendant understands the nature of the plea bargain agreement and the defendant understands the exact plea bargain that has been reached with the state. Is there anything that you do not understand that I've spoken to you about so far?
No.
All right. Then in 2024 CR 5218 to count 1 murder, how do you plead? Guilty, not guilty, or no contest? And then in 2024 CR 5219 to count 1 of aggravated robbery, how do you plead? And to count 2 of aggravated robbery, how do you plead? State any evidence to support the defendant's plea.
Yes, Your Honor. In each of the indictments, state exhibit number 1 with all of its attachments.
Judge, I have gone over those with my client and we have no objections.
All right. Mr. Camarillo, in each of the cause numbers, did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? So what stipulations are you're agreeing that's what in the documents you're saying that's what happened. Do you understand? All right. So again, you can have a jury trial. At the jury trial, the state would present witnesses. Your attorney would have a chance to cross-examine those witnesses. Do you understand? With these stipulations that you're agreeing to, the state is not going to call any witnesses. Do you understand? So the court will be making a ruling on whether or not the state has produced enough evidence to find you guilty of each of these counts beyond a reasonable doubt by reviewing what the state has presented in the waivers and stipulations. Do you understand? In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Oh, off the record, while I'm reviewing this, if you all want to talk with Ms. Ferguson about the date when you all want to come back. All right. After reviewing states exhibits 1 and attachments in each of the cause number, the court will find that there's sufficient evidence to find you guilty, and the court will find you guilty in each count. All right, with regard to sentencing,
Yes, Judge, just a little snafu in that, next week, I know that Zoom may not be available.
no, it will not. Let me ask you, do y'all think they'll be able to Zoom sometime in this week or no?
I checked into that, Judge, and they're not available Thursday, Friday. And so I mean,
Are they available tomorrow?
I can check on that. I mean, if you give me a moment, I can
Yes.
call. Otherwise, it'd be, I think, June 30th, because I know that defense counsel's in trial the following week. But if you give me
Yeah.
a second, I can call.
Okay. Okay. All right, just have a seat. We're gonna see when we can do sentencing. Thank you. All right, who's here on Carlos Saldana? All right, so you'll need to be back tomorrow at 1:30. Yes. All right, Mr. Saldana, if you'll come forward.
They speak Spanish.
Ah. Okay, then, do y'all want to do a bench trial tomorrow or what?
Tomorrow.
All right.
All my clear, my schedule's clear.
Huh?
All my schedule's clear.
Okay, yeah. All right, then, Ms. Ferguson. Saldana is coming back tomorrow for a bench trial. And we'll do it at, let's say, how long should it take?
take but the afternoon.
Yeah.
All right, let's put it at 2 o'clock, Nona. All right, once he signs the reset form, he's excused.
Please get with Judge, he's locked up.
Oh, he is?
Yeah. I'm just joking.
Oh,
But he is locked up.
oh, all right then. Yes. Do you want your client? Oh, it's for me. Do you want him dressed, counsel? He doesn't, I'm not gonna pay attention to dress.
Sorry.
No. Who's here on Teresa Frias? All right, so on this case, what is happening?
Judge, I believe we have an agreement as to resolve the MTR and the new case that's pending.
Let's go.
Yours.
Yes, probation. Oh, no. They said they're gonna resolve the new case
Yes, sir.
and the,
If the MTR is resolved, today, Ms. Frias will be accepted into felony drug court on Friday morning.
all right, that's a great program, but it's a difficult program. If you successfully complete it and take advantage of it, you're gonna do great. And your life will be open up to you, okay? All right. Is there anything, so the motion to revoke, do you all want to wait and handle that after she's accepted, or do we need to handle it now?
I would rather than out there.
All right. So, do y'all have the motion to revoke on Frias? I have the new number. Is it? Just one second. This may be it. Nope, that's Washington. All right. So is she entering a plea on this?
Yeah, well, that was my plan, Judge, and then just our recommendation would be for her to be continued and alter and amended to
be placed in felony drug court and comply with those conditions, just as well as a no contact order with a person in a place.
Okay.
And then we do have an agreement in place to resolve the other cases that she has pending as well.
Okay, all right, the court is calling 2024 CR 011808 State versus Teresa Luisa Frias. Can I have parties announced?
Megan Galloway for the state.
Renee Munoz on behalf of Ms. Frias.
And are you Ms. Frias?
Yes.
All right, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Yes.
Are you the same Teresa Luisa Frias who was placed on deferred adjudication in 2024 CR 011808
Yes.
for the offense of unauthorized use of a vehicle on April 8, 2025 for a period of 3 years? Is that you?
Yes.
All right, state.
Violation of condition number 1 on or about the 8th day of April 2025 in Bear County, Texas. The defendant Teresa Luisa Frias committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
True. We waive and abandon the remainders, Your Honor.
No objection.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there proposed agreement?
There is, Your Honor. The state is asking that you deny the state's motion, continue Ms. Frias on deferred adjudication, community supervision, and alter and amend her conditions for felony drug court. It's my understanding that the defendant did undergo the evaluation and is to be accepted to that specialty court on this Friday. And additionally, we would ask for a no contact order with Walmart stores and a person by the name of, I'm just gonna spell it, it's Nailea Mendoza. And we are taking into consideration cause number 2025 CR 006327.
Is that your agreement?
Yes, Your Honor, it is.
Are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes.
All right, can I have a file stamp for a motion to revoke, please? Oh, no problem. All right, then the court will follow your agreement. Deny the motion, alter and amend to include felony drug court, no contact with Walmart. So that include all Walmarts, you understand?
Yes.
And with Nailea Mendoza,
Yes.
take in consideration 2025 CR 006327. Is there any other recommendations, probation?
No, no contact.
Nailea.
Thank you.
All right, is there anything else you need from the court to be successful? All right, good luck to you. I will, if, I won't say if, when you graduate, if I'm in town, I will be at your graduation. Okay.
Thank you.
All right, thanks. Who is here on Albert Estrada?
Have Your Honor, way to go.
Court is calling 2025 CR 005300 State versus Albert Estrada. Can I have parties announced?
Rick Payne for the state of Texas.
George Schaefer for defendant, Your Honor.
All right.
Speak loud for the court reporter and the judge to hear you, okay?
And is this an application?
No. I'm sorry, it is, Your Honor.
All right, probation, this is an application. It's Albert Estrada. Are you Mr. Estrada?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review with your client? Court will find that the state is in compliance with discovery. Mr. Estrada, did you review the application for community supervision with your attorney?
Yes, I
Did you understand it and sign it?
Yes, I did, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did. Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we will waiving the repeat offender enhancement.
We have no objection to the state's waiver of that.
All right, did you review the court admonishments with your attorney? Did you understand it?
Yes, Your Honor.
Did you understand you're charged by indictment with failure to comply with registration as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison
Yes, Your
and up to a $10,000 fine.
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Off the record for a moment. Deputy Laura, the person in the t-shirt, how old are they? Okay. How old are you?
For a white t-shirt. How old are you, sir? Yeah, they just didn't have them all.
All right, we're back on the record. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, I do.
All right, off the record. How old is this person here in this black t-shirt? Yeah, show him your ID. All right, we're back on the record. Did you understand by entering this plea, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as the factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor. Yes, sir.
Mr. Estrada, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no.
Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. State recommends community supervision. They're taking in consideration 2025 CR 005376, and there should be Chapter 62 compliance. Did you understand that?
Yes, sir.
Did you understand that to be the plea?
Good, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, they're requesting that your community service be for a term of 4 years, 100 hours of community service restitution, MIC evaluation, follow all recommendations, DDRF, TAP evaluation, and follow all recommendations. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, I understand.
All right, so what I can tell both parties based upon what he's going to be on probation for, if I follow this agreement, there's no community service hours for him. They're not gonna find a place.
Okay.
The other thing, probation, is he able to do DDRF based upon his offense? Okay. I don't know if they'll accept him. So. All right, so he's not able to do that, and he won't be on the MIC caseload, will he?
No.
All right, so
Could
obviously
make an
there's some,
amendment to remove those and put on the zone, please.
oh, I mean, I'll just, what do y'all want to put down? Because what I can do is, what I can tell you based upon what's outside the recommendations, it appears that there's some mental health issues or something else that's going on. So I can ask for a referral to Center for Healthcare Services, but he doesn't meet the criteria for probation.
I think that, and then the specialty
Yes, all
supervision would be the best thing.
right. So you understand that you don't qualify for DDRF or the mid caseload. They're gonna have you on a special caseload. And I'll do a referral to for Center for Healthcare Services, and they'll address any type of mental health issues there are. That's all I can do. There's no other placement for me to put you. Do you understand?
No,
All right, so your attorney wants you placed on the mental health caseload.
no.
And he wants you placed on that caseload because obviously he's determined that there are some mental health issues that are at play here. Maybe you've been previously diagnosed with bipolar schizophrenia or something of that nature. So he wanted you to get help through that program. That program is not available for you due to the nature of your offense. Then he wanted you to be considered for DDRF, which again is associated with persons who have mental health issues. But based upon your charges,
And I have Dr. Mary Jo Rodriguez, I don't know if you know her.
yes, that's why I'm saying you're going to be referred to Center for Healthcare Services. That's what I'm saying. Instead of that, because you don't qualify.
Okay, well, she's the one that wanted me to go out there too, because so she continue on.
You don't qualify for that. And when I say you don't qualify for that, I can't order it. And probation, if I were to order it, probation can't follow through on that because you don't meet the criteria to be placed there. Because sometimes when people are charged with violent offenses or certain offenses, then according to the government funding source, you're not allowed to have violent offense as a part of the program. I'm not saying your offense that you're seeking probation for today is a violent offense, but the underlying reason for your having that registration, that is why you're not eligible for DDRF or the MIC program. So your attorney feels that you have mental health issues, so we're just gonna have to find another placement, and we're gonna do that, okay? All right, then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor, at this time, state orders into evidence, state exhibit 1 with all attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I'd like to say this, Your Honor, for many, many years, he has reported annually as required to. Last year, he had witnessed his brother shooting himself, and he was depressed over it. I've explained to him that depression is not a defense to these offenses. But I wanted you to be aware of that.
I take full responsibility, but I let my depression get the best of me on that, so it caused me to isolate myself and seclude myself from civilization, and basically put myself in a dark hole. And just recently coming back in here I thought kind of exercises help me deal with the depression. And because it's an experience that I wouldn't want to wish nobody with that, you know what I'm saying? After what I witnessed, I could have easily gone back to prison for 20 more years than what would I witness, And then on top of all that, just when I was coming back up, my mom died the same way. In my arms, same room, same house. So the reason I got myself into this trouble is because my dad and my older brother felt like that they needed to sell the house, which I was the only one that was fighting it because I didn't want to lose their memory. But I've been on this program for 25 years, never missed. I was done with that. But like I said, it was something new to me that, after witnessing him take his life in front of me, it's kind of like this, I lost myself. Like I said, I'm going to take full responsibility for that. I know what happened with him, but I let my depression get the best of me. So I just want a chance to go back and I want the court to be aware of that.
All right, thank you for letting me know. All right, so I'm finding you guilty. The court is going to sentence you to 4 years in the prison, suspended and probated for 3 years, $1,500 fine, probated. You're going to be registered by the Special Offenders Unit. Well, supervised by the Special Offenders Unit. There's going to be regular reporting, regular random UAs, a referral for Center for Healthcare Services, TAP evaluation out of custody, follow recommendations. There's to be no residing with minors in Chapter 62 registration. Probation, is there anything else? All right, I'm so sorry. Are you employed? Were you employed before
I
you?
was employed, but like I said, I kind of lost my motivation, but and then, like I said, it's just.
All right, so this is what I'm going to do because I know it's hard for you to find employment. Proof of employment within 60 days of release, no employment as a home health care provider or with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. And if for some reason things don't work out with your getting in touch with Center for Healthcare Services.
No, I have that this time around, I have a lot of resources that I will refer to, and I have a lot of people that are trying to help me out.
All right. Well, if you need anything, we're here. Let your probation officer know. If you feel as though they're not addressing it, you can always come back to court and speak to me about it, okay?
I appreciate that, miss.
All right, good luck to you. I'm sorry all of that happened to you.
I'm sorry. Thank you.
You're welcome.
Right over here, sir. Right over here.
All right, Camarillo. What date?
Friday, Judge, this Friday.
All right. We will see you on Friday then.
Yes, Judge, he checked with the family. on Friday the 13th.
Well, you know, there's a movie you should be concerned about Saturday, the 14th, not Friday, the 13th. All right, so we're going to bring you back on Friday, the 13th, okay? And that'll be your sentencing. Do you have any questions about anything? All right, we'll see you then.
Thank you, Judge.
You're welcome. All right, who's here on Rudolph Brasenio?
I'm here, Judge.
All right, where's he?
He's not here, so I have attempted to contact him. Have been unable to do so. So I just
All
wanted
right,
to
is he
check.
on a commercial bond?
Okay.
All right, the court is calling 2025 CR 004-546 and 2025 CR 004-541, State versus Rodolfo Brasenio III. Can I have parties announced?
In Galloway for the state.
Lauren left in for Mr. Bus-
All right, this hearing was called at 9 a.m. The defendant did not answer docket call this morning. Deputy Laura, was an announcement made? All right, have you had any contact with your client?
I've attempted to contact him, but no response.
All right, State.
We're requesting a judge's warrant, Your Honor.
All right, that will be granted and your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you.
Thank you. All right, who is here on Alfredo Campos? And then after that, I'm getting close to you, Mr. Davidson. All right, so we're here for discovery.
Yes, Your Honor, discovery seems to be sufficient at this point. We were also extended an offer. My client has rejected. We're wishing that this case be set for jury trial.
All right, I'll need an acknowledgement of discovery signed. How long do y'all expect this trial to last?
Maybe 3 days.
All right. He wants a jury trial or a bench trial?
Jury trial, Judge.
All right, look, he didn't even flinch. He's like, jury, we don't want to come to you, judge.
Explain the options with the client even.
No problem. All right, Ms. Ferguson, I need a jury trial. It's family violence. If y'all can approach her and agree on a date and let me know what the date is.
Yes, Your Honor.
All right, thank you. All right, so on this case,
Similar situation, Judge, discovery seems to be sufficient. I know at the previous setting, I was requesting video. It seems that that video is not in existence. It's from a covert officer. So we're also extending an offer today. Client has rejected said offer, requesting a jury trial.
all right, and Yeah. For Mr. Leal, I don't have one case. I don't have his other cases. But if you'll confer with Ms. Ferguson. State, how long do you expect this case to last? It's a drug case and possession of body armor and possession of a firearm.
A day.
All right, 1 day, Ms. Ferguson.
Is that with jury selection? Is that with jury selection or just?
That's
test?
just the state's case, yeah. Oh, yeah. It was fine. All right, Mr. Davidson. Your case has been taken care of.
Thank you.
You're welcome. Thank you for your patience. All right, let me know the date. Yes,
On that one, Judge, we came in agreement with the July 22nd.
all right, we'll see you then. All right, thank you. When you're ready.
Ready. Your Honor, there was something put up there, and that was from yesterday. The client is not present. He's in jail.
I'll go draw it.
Promise.
Yes.
Mhm.
So I got the sticky note. So let me see, what was your agreed bond?
It was 30, Your Honor, and you,
Was that his previous bond amount?
yes, Your Honor, but now should have been out.
Mhm.
But for somebody that I guess doesn't normally work in this court, the clerk closed the bond out. Was it?
All right, here's what I've done is I put a bond amount on here.
Okay.
Okay. So that's all I can do. Yeah. If you can make sure that's in the system. All right, thank you. All right, Luis Beltran. All right, you all are scheduled for jury trial,
Yes, Your Honor.
so you all will have to come back tomorrow because we're currently in the trial.
Thank you.
All right, thank you. Oh, you here? Oh, come forward. Hello, how are you doing? All right, so your attorney is not present. So you're going to be recalled for tomorrow.
Okay.
All right? So we'll see you then at 9, okay?
Okay, thank you.
You're welcome. Once you get the reset form, you're excused. All right, thank you. Jesus Arez Mendez. And does he only have one case?
He had several cases. This is a restitution hearing setting, so we did a plea for probation and dismissal. It's about 10 days ago with Mr. Edelman. And we were to come here today to have a determined amount of restitution.
All right, State, do you have an amount of restitution?
Just as you were calling us up here, I did get a figure for the victim, I believe it's Milton Zorate, of $600. I just trying to confirm, sorry, Judge, this is Andrew Edelman's case, but well, my understanding now, I just gotta, sorry, I'm reading off my phone.
No problem.
That's correct. It's $600 total to Duarte for all the cases.
And did he provide any documentation?
Well,
I know it's hard to get.
not off my, but I mean, just to let you know, it says for the expense of the tools stolen and also the damage to the ignition column. That's what it was
Well,
just
that's
stated to
getting
me.
off light for the damage to the ignition column, because that's usually more than that.
That they just spoke to the victim on the phone, just probably minutes ago.
No, I'm just saying that to say he's being reasonable, because the damage to an ignition
yeah.
column is more than that.
That's what I would figure too, Judge.
If you're going to the dealership for the damage to the
That's just labor.
column, oh no, that's time when you drive on the line, just for them looking at it. And you see all these shows where you try to negotiate the price down.
Mhm.
They don't do that.
Yeah.
I tried that
Oh,
one
yeah.
time, and they're like, there's nothing we can do. That's the labor.
Yeah, I agree.
Yes.
So I spoke with my client. He's willing to accept just Mr. Garahan's statement that the restitution is 600. as a final amount. And we just would ask that he be released and so we can start his probation.
All right, so $600 to, and what is the name of the complainant?
Judge, I have it as a Milton Duarte. Last name is spelled Duarte.
All righty. All right, and then, let me see. So has he completed his TAP evaluation?
Sounds like he did, and he said outpatient treatment was recommended.
All right, so, probation, if he's completed all of his in-custody evaluations, whatever the recommendations are for that, then he can be released. Oh, no problem. And they're supposed to have done the gang evaluation as well.
No recommendations. Happy evaluations, they did the recommendation is for basics and outpatient treatment and document minutes of court meetings. It's also recommended to the MAX program.
Okay.
And I don't have anything in regards to the gang evaluation. I would have to check on that.
All right, do you have any prior gang affiliation? I'm sorry, what? I'm not talking about right now.
No, I don't, I'm not, that's my past.
So my question is, do you have prior gang affiliation?
Yes, ma'am.
All right, so they probably still have you on the books as a gang member. So, Ms. Abrams, if you can make sure the gang evaluation is completed. What do you recommend? I'm sorry?
I said, are we still holding the
How long will it take for a gang evaluation in custody? All right, so here's the. All right, she's gonna reach out to the manager. Let me explain something to you. One, they're gonna recommend that you're on gang supervision. Gang supervision, Deputy Laura says, is not as intense as my probation. So you can wait in custody for the gang evaluation. It's gonna say gang supervision and you're gonna be placed on it. Or what's gonna end up happening is probation is gonna come knocking on your door at any time per week till the evaluation is completed. Now, if you're under gang supervision, they don't come see you weekly. But if I believe that you have gang affiliation, then probation, when they do field visits, they're going to come knocking on your door weekly at any time. And they'll do it once a week. Gang supervision is not weekly supervision, but my supervision until you're under gang supervision is weekly supervision. Here's my thing. You know you better than I know you, better than your attorney knows you. Now me, if somebody were to come to my house on a weekly basis, they're not going to find anything illegal because they're not going to know where to search. I'm just joking. I'm joking. Laura, were you waiting for that punchline? No, but the reason why I tell you this is because you're on probation and you have to walk a fine line. You know better than I do your abilities. Now, what I'm telling you is for gang supervision, until you're placed on gang supervision, I'm going to ask probation to come weekly by your house. And they're going to knock on your door and you have to let them in.
That's fine with me. I'm trying to change my life. So.
All right, I hope you're changing your life then.
Great.
Okay.
And Judge, after that, I just
Yes.
needed to put a I think there's two last names for the victim,
Okay,
and I just wanted to give the other name when you have a chance.
oh, I'm ready.
Oh, it's Porcayo? I mean, it's spelled Porcayo. And I'll supply to probation a phone number to reach that individual at.
All right, so Milton Duarte has a $600 restitution.
Right.
And then Porcayo,
That is the same individual.
oh,
Yeah, yeah, it's just, I believe he has a hyphen or two last names, I guess you could say it that way.
okay. All right,
Thank you, Judge.
and then, so there'll be, oh, wait a minute, she may have something for us. So, Mr. Ares Mendez, I have to make sure that everybody is on the straight and narrow when they're under probation with me. If gang supervision is supervising you, then I know they know certain things that need to be done. But I can't send you out in the world without supervision, intensive supervision, knowing that you have prior gang affiliation. That is something I won't do. And I know that everybody says, I'm changing my life, and some people do, but then some people don't. Mhm. Yeah, we're ready. But they warned you and you still went out to get tear gassed.
I didn't think there was gonna be tear gas.
They didn't put that part in there.
I knew there was gonna be police and riots.
Yeah. They didn't do that.
He said he has documented and they could get him into, there is no wait list right now, so they can give him an intake next Wednesday.
All righty. So does he need to stay in custody for that? All right. So next Wednesday.
So how probation works is you're gonna get released hopefully in the next 24 hours. So then you need to report to probation right away. So if you get released tonight, you go the following morning, then you're gonna have an appointment. And I'll make sure you have my contact information so that if you don't know where to go for that appointment on Wednesday, you can call me Tuesday night. So we know where to send. Sound good? Sounds good.
All right, in this court, to be successful on probation, communication is key. If there's an issue, you need to let your probation officer know about it. If you feel they're not addressing it, you can always come back to court. If I'm here, I will address it. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
For gang diversion programs, the outpatient treatment, schedule your analysis, sober support meetings, and the restitution.
Yes.
Thank you.
And there should be already, as part of his condition, he's not allowed to reside with minors.
Yes.
Okay. All righty.
I'll make sure.
Thank you. Hello, Mr. Lampkin. Oh, could you all address yes, thank you.
No, it's not on me.
Hi. All right, so this is what ended up happening this morning. The bus broke down, so they couldn't transport him over. Then there were some issues, and I'm sure, as you can understand, sometimes when people have mental health issues, it has to be a regimented schedule, and when things go off kilter, everything goes off kilter. So I was told that you had some concerns about his physical well-being. So the deputies, I asked them to call over to the jail. Deputy Laura called over there to see what's going on. I asked the court coordinator to have him by Zoom so that you can see him.
Thank you.
So you're welcome. So Deputy Laura, is he okay at the jail? So, and what I can tell you in this court, if somebody wasn't doing well at the jail, anytime somebody tells me, it could be the parents, it could be the relative, they'll let me know. If they think that something's wrong at the jail, I'll ask the deputies here, who I trust, to call over there to see what's going on. And they will give me detail, because at the jail, especially when you have persons who have mental health issues, everything has to be documented, because otherwise you'll get in trouble with the government. So everything is documented. So he's doing okay. The reason why he wasn't here is because the bus broke down.
Yes.
And there's not another bus for him. So his attorney, Michael DeLeon, is still working on trying to get everything arranged so he and the state can come together on what would be an appropriate outcome for these cases. So that's what he's working on. And as you all know, when you're dealing with mental health or physical health or something of that nature, it takes longer. So we're going to come back, Mr. Lampkin. We're going to come back on your case on the 22nd. All right?
I just have a question.
Sure.
Why are they treating me like this at the jail? Like I haven't been able to shower, eat.
All right. So I'm gonna talk to them about your ability to shower. But what I can tell you is when you're dressed in a red outfit, like you're dressed in, they only allow you out of the jail, out of your cell at certain times. And then during that time frame, you have a chance, you're supposed to shower, and then they have for you to do an activity. But, I know everybody wishes the shower time could be longer, but when you think about the number of inmates they have at the jail, they can't give somebody a 30-minute shower. So I will check, Mr. Lampkin, I will check and I will call the sheriff and I will check on whether or not you're being allowed to shower, and I will do that today.
Can I please say something?
Sure.
Can we ask Malik if he is eating and drinking, please?
All right. Are you eating and drinking food? Drinking water or something and eating?
They allow me to.
So let me ask you this. Did you have breakfast?
Yes, I did today, yes.
All right. Did they give you lunch?
After a while, yeah, they did, yeah.
All right. Have they been giving you dinner?
We'll see if they give me it today. They haven't been giving me it for a while. I know what the problem is.
All right. So what I can tell you is this, miss.
Oh.
Unless you tell them there are specific dietary restrictions you have, everybody gets served the same thing. I've been over at the jail. I've watched them make the food, serve the food, because I'm always interested. And I was always interested as a defense attorney. If I have a client who's at the jail, I need to see what the jail is about. If I had a client who was at the state jail facility, I would go to the state jail facility because I want to know where my client is. So what I can tell you is for lunch, it's usually a bologna sandwich with some fruit. And do they give them milk or water?
This is Deputy West.
Yes.
And most of the time they get a vegetable, some type of dessert, bread, some meat, and some juice every day for lunch, for their 3 meals.
And then how long are they allowing the persons who have mental health issues to shower?
Anybody in Red here, ma'am, they come out for 1 hour a day by the Texas jail standards.
All right, thank you. Do y'all have any other questions?
Yes, Judge, because I know that's why they were, motioning for Malik to be transferred to the rehabilitation center, because I did tons of research and noticing that especially people with mental illness, that every time Malik has a schizophrenic episode or going into psychosis episode, he gets thrown into the isolation cell, which is, the all day, and then you get let out for 1 hour, which I know, especially for people with mental illness, could be considered cruel and unusual punishment, because their mental is already, low, and then it's declining more and more because then he doesn't get out. And usually I can tell you, Judge, my son, he was calling me like 5 or 6 times a day. And the last time I spoke to him was about 5 days ago. And he said, Mom, I feel my mental slipping again. And I said, well, Malik, tell them so they can help you. And then I never heard from him again. And so I got concerned and I called the jail myself a couple of days later. And they told me that that he's been thrown in isolation and he just left medical because now was in an altercation.
Well, what I can tell you is this. When people go to the jail, if they have mental health issues, they get their classifications. And, this is why I tell everybody, you have to write your legislature, because funding, nobody has funding. And so they have to make a determination what is safest for him. If he is having outbursts and there are mental health issues, general population may not be safest for him, because if he has a mental outburst, or if he is having psychosis or something is going on and he strikes another inmate, that inmate is probably going to strike him back and there's going to be a big fight. So at the jail, they do try to classify people whether or not they should be in general population or not. Now, if he has a mental health diagnosis, which he does, they have nurses that will come in to see them to make sure they're taking their medication. Legally, they can't force them to take their medication. You have to have a court order for that. And that doesn't happen until you go to the civil court for forcing of medications. So the jail is really not the place for people who have mental health illnesses. But your problem is your son is sort of in a little bit of a limbo area. The reason why he's in limbo is he has a new case, and that new case has to be taken care of. But then he has the mental health issues. If he didn't have the new case that was open and pending, there would be more that I could do for him and more that his attorney could do for him. But right now, that new case needs to be taken care of. However they decide they're going to take care of it, whether it ends up in a jury trial or what. And then, the other placement and all of those issues can be addressed. But with what he's charged with, there's not going to be a placement that will take him, because they're looking at potential civil liability, because they know what he's charged with and that it's alleged to be a violent offense. I don't take it as true because I haven't heard any evidence. And so there is no other facility that's outside the realm of a facility for people who have charges like these that would accept him, because they're looking at different liabilities and they have their governmental standards that they have to abide by on who they can accept. But what I can tell you, if you have a concern about his safety or anything, of course, you can always let this court know, and you can always go to the jail or call the jail and let them know, hey, these are my concerns, and they'll address them. You just have to make sure you let them know.
And Judge, one more question. Instead of him being in the isolation, is it possible to be transferred like to the hospital setting? Like
What I will tell you is the jail, they're in charge of transportation. They're in charge of whether they're in isolation or not, because the jail is in charge of safety and security. I have no control over that.
Yes.
Whether or not he's transported to a facility for mental health, that really depends on certain motions that his attorney filed, and then certain rulings that are made by the court that would hear that. And that's a quasi civil matter because it has to do with mental health.
And that's another thing, Judge. What if we can't get the court-appointed attorney to file any motions?
Oh, so here's the thing. This is what I tell families. You may think a court-appointed attorney is moving slowly. Sometimes people will say, oh, this court-appointed attorney, I just don't like them. I think they're horrible.
Well, he's
And
a very nice man.
no. But let me just tell you. And then you know what they do? They go out and hire someone. And then the people who know who the attorneys are, they are stunned that they let such a good attorney go, and that attorney was basically free. So what I can tell you too, sometimes attorneys, they're very busy and they already know that your son is an adult.
Yes.
So really, they don't have to bring you into the conversation because he's an adult. And I would always tell clients, look, I can't bring your parents into this conversation because what we're saying is confidential. And then sometimes if I'm bringing your parents into the conversation every day, then I can't work on your case because I'm busy having a conversation with your family every day. So what I can tell you is this: the attorney that was appointed to represent your son, if he was not qualified to handle these type of cases, he would not have been appointed to represent your son. Okay?
And am I allowed, Judge, if I have power of attorney and also medical durable power of attorney over Malik, can I file motions pro se on his behalf?
All right, so let me explain something to you. Now you're asking me legal questions, and I'm not allowed to act as an attorney or give anyone legal advice.
Okay.
But I would suggest to you to call his attorney.
Yes, ma'am. Okay.
Okay.
Thank you, Judge. Thank you for doing this for me. I more than appreciate this. Thank you.
Oh, you're so welcome. I understand. All right, you're welcome. You're welcome. And if you talk to his attorney, I'm sure his attorney will speak to you. All right, thank you. All right, Deputy Laura, can you let him know he can be excused, Norma?
Should he did there, should have did there.
All right, thank you, Deputy, for bringing him.
Put him with the pump, nigga, clear.
All right, it's the court's understanding that the jury has signified that they've reached a verdict. So we're back on the record in 2024 CR 009. I'm sorry, 006-930. State versus Alexander Rodriguez. Could I have parties announce?
Not done and recommended for the state.
Marissa Fernandez Pat and Marissa Giovanco waiting on Alexander.
Okay. All right, so to people in the gallery, we've been informed we have a verdict. So this is what I'm going to tell everybody. And I want everybody to hear me clearly. There will not be any outbursts. There will not be any cheers. There will not be any tears. We're not going to have that because that puts the deputies on high alert. And then you know what's going to end up happening? Whatever side you're on with the cheers or whatever it may be, a deputy is going to tap you on your shoulder and you will not be coming back to this courtroom unless you're called as a witness. And there's not going to be any explanation needed because that's how it's going to be. So let the deputies have an easy job today. All right, the defendant is present in the courtroom. Are both parties ready to receive the verdict?
Yes.
All right, let's bring the jurors in.
All right, for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict in this case. Is that correct? And is the verdict unanimous? All right, if you'll hand the verdict form to the deputy, please. All right, with regards to count one, it states, we, the jury, find the defendant guilty of the offense of continuous sexual abuse of a young child. Count two, we, the jury, find the defendant guilty of the offense of indecency with the child. And count three, we, the jury, find the defendant guilty of the offense of indecency with the child. Does anyone wish to have the jury polled?
Yes.
All right, ladies and gentlemen, I'm going to ask you if this is your true verdict. If this is your verdict, I need you to answer yes. Does everyone understand?
Yes.
All right, so we'll start on the front row. Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict?
Yes.
All right. Thank you. So you have done your service in this trial. So I'm going to have you, Deputy Laura, take you all to the back and I'll come back and speak with you briefly, okay? Everyone, please rise for the jurors. All right, everyone, please be seated. All right, so legally, I don't need to do a PSI. We can have a hearing now for sentencing if both parties are ready to proceed with sentencing. All right, I'll let you speak to your client. I'm going to speak with the jury and I'll be right back.